This podcast is brought to you by the School of Advanced Study, University of London. All of our podcasts are available from our website, www.sas.ac.uk.
Thanks for inviting me, and apologies for my voice, which is not the normal foghorn that addresses 450 first-year students, so I hope I remain audible for the next 20 minutes. Let me just start with something that I imagine most of you know. A refugee, according to the 51 Refugee Convention, is someone who has a well-founded fear of being persecuted for reasons of race, religion, nationality, and so on. And in order to demonstrate that their fear of persecution is indeed well-founded, asylum applicants must show that people of their background are at risk in their home country. Moreover, the most effective way of demonstrating future risk is to show that they themselves were persecuted in the past. But the story they have to tell is often the only evidence they have, and the key question for decision makers is whether they believe that story. The focus is on credibility in two senses. Is their story internally consistent over dates and places? And is it externally consistent with information on their home country? And that's where country of origin information, or COI as it's commonly called, is crucial in almost every asylum claim. And this point is made by the UNHCR handbook, paragraph 42. The same point is made in the European Qualification Directive, and it's been explicitly stated in asylum jurisprudence that if a judge fails to relate an appellant's story to the background evidence in the appellant's country, he's necessarily applied the wrong approach. Now, just very briefly, some background. Asylum claims in the UK are administered by the UK Border Agency, a branch of the Home Office. There are a series of interviews that are conducted, at the end of which a decision is taken. And most often that decision is a refusal of the person's claim, and a reasons for refusal letter is written, justifying the refusal of asylum, and the reasons are normally that their story is said to lack credibility and to be inconsistent with the COI, the country of origin information. In most cases, these refusals can be appealed to an immigration judge in the tribunal, and asylum seekers are normally represented in court by barristers. UKBA is represented by a Home Office presenting officer, who's generally not a trained lawyer. The hearing begins with a brief examination in chief, followed by quite a lengthy cross-examination, in which the hoppo is trying to find inconsistencies or apparent inconsistencies in the asylum seeker's story, which can be used to cast doubt on their credibility. And in their closing submissions, hoppos will attack the appellant's credibility, and they'll also cite COI supporting the decision taken by UKBA. The barrister will then rebut the credibility points, or try to, and offer rival interpretations of the COI, and the judge must later produce a written decision saying how much weight was given to each piece of evidence. The official source of COI in the United Kingdom is the Country of Origin Information Service, replacing its predecessor CIPU, the Country Information and Policy Unit. And it produces country reports at roughly 6 monthly intervals on the top 20 or so asylum countries, countries of origin. Now, these reports in the past were very severely attacked for all kinds of inaccuracies and misleading information. They've improved out of all recognition in recent years, and they now consist entirely of attributed quotations from cited sources with no editorial content at all, although of course you could still ask why those sources and not others, why that particular passage is quoted and not some other. Hoppos in their submissions in court draw their COI almost entirely from these country reports. But although barristers use them as well, they will usually also submit generic reports by NGOs or medico-legal reports or reports by country experts like me. Now, doctors who write medico-legal reports are expected to follow certain protocols like the DSM-4 for PTSD diagnoses or the Istanbul Protocol in cases of scarring. For country experts, there are no protocols, there are only the general rules on experts given in the civil procedure rules, and the very similar rules given in the tribunal's own practice directions. Experts, country experts, generally get no advice from their instructing solicitors either, so they're left to their own devices very much when it comes to structuring their reports. That's the typical structure of a report that I might write, including some of the issues that most commonly arise in Sri Lankan cases. Though, of course, it will depend on what instructions I'm given in that particular case. Now, there is, of course, an inbuilt tension in this system. On the one hand, although the legal process is adversarial, the expert's overriding duty is to provide balanced information to help judges reach decisions. And yet experts are always hired by the lawyers representing asylum applicants. UKVA never uses experts of its own. So hoppos tend to see experts as hostile witnesses. And many judges, too, suspect them of being hired guns, providing evidence because they've been paid to do so, or because of their political sympathies. Now, when I was first living in Ceylon, back in 1971, it became the Republic of Sri Lanka, with a new constitution lacking earlier safeguards for the Tamil minority. I was actually at the ceremony where it became the Republic of Sri Lanka. In those days, there was no security. You could just walk to the front and sit down in front of the Prime Minister. This led ultimately, this lack of safeguards for the Tamil minority, led to the appearance of various militant Tamil tiger groups. And from 1990 onwards, the largest tiger group, the LTTE, was in control of large parts of the north and east. After a decade of military escalation, a formal ceasefire was signed in 2002. It was closely observed at first, but there was a gradual slide back into violence. The conflict ended in 2009 with the military defeat of the LTTE and the deaths of huge but still unknown numbers of Tamil civilians. I made visits to Sri Lanka in 2003, 2006 and 2010 with a British immigration lawyer to collect human rights information in Colombo, Jaffna and Batticaloa. And I'll mention just one of the many issues that arose during those visits. The Sri Lankan government in 1996 had created a National Human Rights Commission, which was clearly a positive step. But the Human Rights Commission had problems implementing its mandate. For example, although staff could visit official authorised detention centres, many prisoners were held in unauthorised places, which were not accessible to it. And most crucially, its mandate did not cover pro-government militias, who in practice do the security forces' dirty work for them with regard to abductions and disappearances. UKVA refusal letters in 2003 routinely included this paragraph. It was just cut and pasted into virtually every report. And it was clearly important, therefore, to assess at first hand the conditions under which the HRC was operating. And during our first visit in August 2003, while the ceasefire was still being closely observed, the land route through LTTE territory to Jaffna in the north was open, so we were able to make this journey, and I spent a day at the HRC's Jaffna office. A UN human rights trainer based there told me about HRC's narrow operational definition of torture, which was limited to physical ill-treatment. I also learned that the HRC's response to complaints was a mediation process in which the torturer was asked to pay a small amount of compensation, and if they did so, they faced no legal or disciplinary proceedings. Moreover, the HRC's head in Jaffna, Mr. Chandrasekhar, faced army harassment. He showed me a letter from Jaffna's military commander concerning Mr. Chandrasekhar's refusal to allow an armed soldier to travel in his vehicle on the grounds that HRC must remain neutral and independent. The letter stated in strong language that soldiers had been ordered to refuse such demands in future. In September 2004, after my visit, Chandrasekhar was assaulted by police while investigating a complaint. And although he brought a case against them, before that case was heard, he'd been forced to flee to Canada, where he was granted asylum. Now, this kind of information is important in assessing HRC's capacity to oversee the human rights improvements constantly referred to in refusal letters of the period. One day observing an HRC office scarcely qualifies as anthropological fieldwork, but it did provide me with insights that were helpful in many asylum cases. In particular, it allowed me to illustrate to judges the practical difficulties involved in monitoring human rights observance on the ground. However, legal responses to that kind of evidence, which I should emphasize is very much in the minority in terms of most of the evidence I provide in my reports comes from more conventional sources. It's not based on my own fieldwork. But where it is, there's a curious reversal in legal processes from the situation in academia. Among my academic peers, the element most immune from criticism is my own ethnography. As James Clifford pointed out, "I was there" is a clinching argument unless you're willing to question my honesty or my competence. But in legal contexts, my ethnography may be dismissed as anecdote, and prime authority is given to documents. For example, the first two of these field visits led to public domain reports, which I made available for general use in Sri Lankan asylum appeals. And in those reports, I disavowed any claims to completeness and made clear that I was simply reporting what had been told to me by specified informants. So apart from passages where it was clear I was describing what I saw on a particular journey, the entire report consisted of paragraphs like this. I've since removed the names of the actual people and organisations for reasons I can go into later if you want. They were there in the original report. But virtually the entire report consisted of material of that kind. Now, even so, one judicial panel, faced with this visit report in a case where I'd not been specifically instructed, so they didn't have a specific report by me, they only had this one, said the following: although Professor Good is plainly qualified by his experience and background to give expert evidence on the matters covered by it, he has fallen into the trap of expressing his views freely but failing to identify his sources. Now, I was completely bewildered by this, bearing in mind that that was the kind of material that they were commenting on. And I'm still bewildered by it. I still don't understand how my report could have been read in that way. And I can only assume that this is a kind of genre mistake that doesn't recognise this particular kind of evidence and fails to understand the nature and status of the sources that I was using, which of course my material derived mainly from people rather than from documents. And now, turning to a slightly different issue, in countries where there are large numbers of countries generating large numbers of asylum applicants, the same issues tend to recur over and over, the same country issues. Is it safe to send someone back to Colombo, for example? It occurs over and over. And it would clearly be inimical to justice if different courts came to radically different decisions on questions like that. And in order to try and minimise that risk, the tribunal introduced in 2000 the idea of country guideline, or CG cases, which would carry out very detailed assessments of the country information on particular issues that commonly arise. So a CG determination, as the Court of Appeal described it, is a kind of factual precedent. The tribunal itself doesn't like that terminology, but that's what the Court of Appeal said. But the Court of Appeal, while approving of this, drew attention to certain caveats, as in paragraph 29. But it has to be said that many early CG cases completely failed to live up to those standards. Some of them cited only one source of information, the Coy's country report. Now, you can't say that now. It's commonplace for them now to cite hundreds of sources, so that particular criticism can no longer be levelled. But one can still sometimes question how comprehensive and balanced those sources are. Now, of course, that's not the fault of the judges, that's the fault of the lawyers who are presenting the evidence in front of them. In FS, for example, the country guidance case on apostasy in Iran, the tribunal considered a large body of country information in what, from what I can tell as a non-specialist on Iran, was fair and balanced fashion. But the material on religion from which they drew their information came entirely from Christian authors. There wasn't a single source that represented the views of Muslim scholars writing as Muslims. And as a result, the tribunal's analysis was riddled with Orientalist presumptions, most notably the conflation of Iranian law with Islamic law. Now, whatever its merits in promoting consistent decision-making, the CG system also raises a rather intriguing problem for country experts, as I've already experienced on 2 occasions. The problem here is that while lawyers may be bound, but they have no choice but to be bound by factual precedents, experts, in my view, cannot be, because with the greatest respect, the opinions of British judges on the prevailing situation in Sri Lanka carry no weight at all for me as country evidence. And I cannot ignore a particular piece of evidence simply because a judge has already come to a view on it in a previous case. And to be a little provocative, if judges are going to reserve to themselves the right to decide what country information is relevant to my or any other expert's opinion, then it's hard to see what the point is of having an expert at all. They're not free to choose for themselves what's relevant. Now, the eminent legal scholar William Twining argues, and he's not talking about asylum here, he's talking about law and legal training in general, that techniques for assessing factual evidence, which of course is what asylum decisions are mainly concerned with, receive little attention in law schools and the work of academic lawyers. So being relatively under-theorized, judges' assessment of factual evidence tends, he says, to reflect a relatively complacent common-sense empiricism. It has devoted far more attention to the rules of admissibility than to questions about the collection, processing, presentation and weighting of information. Now that bias in legal education, if he's right, and I assume he is particularly problematic in asylum cases where admissibility isn't really an issue at all, because any kind of evidence virtually is admissible. It's simply because the strict rules of evidence don't apply. It's a matter of how much weight the immigration judge is going to attach to that evidence. For example, as an example of this common sense empiricism, it's been standard practice in British immigration courts to refer to COI as objective evidence, which appears to take no account of the contextualization and interpretation to which all such knowledge is subject. Now that usage has come under criticism from judges themselves recently for a slightly different reason. But I think in any case it's less disconcerting once one recognises that for lawyers, unlike philosophers and social scientists, objectivity, if you like, is a pragmatic and not a metaphysical notion. Rather than implying something external to the observer and therefore capable of independent verification, it plays much the same role as the notion of the reasonable man for the Barotse judges described by Max Gluckman in one of the founding texts of legal anthropology. For lawyers, in short, objectivity is little more than the subjectivity of the reasonable man. So it's less disconcerting for me to realise that if I were to claim objectivity for one of my expert reports on Sri Lanka, I would merely be stating that no reasonable expert on Sri Lanka would be likely to reach different conclusions. UKBA's position was revealed by an argument advanced in the, an argument advanced in the 2006 CG case, LP Sri Lanka. UKBA's lawyers were particularly concerned to try to minimise the weight of evidence by Chris Smith, a British security specialist, which was drawn from his interviews with key officials like the Inspector General of Police. And in their written submissions to the court, UKBA argued that an expert witness in asylum cases differed from experts in other forms of civil litigation. Normally, it argued, experts used their specialised knowledge to interpret the significance of, for example, medical diagnostic findings. And it went on to say the role of a country expert is rather different. It is unlikely that any specialist knowledge is required in order to interpret the information. Well, there's the whole discipline of anthropology out the window in a single sentence. Rather, the role of a country expert is to assist with the provision of the raw data. UKBA, in other words, was trying to limit country experts to mere gatherers of factual information for judges to interpret. And the reference to raw data laid the groundwork for a further argument in court. Dr. Smith's evidence should not be accepted unless he also provided his interview notes made at the time. Now, this argument was no doubt largely tactical, but the very fact it was deemed worth advancing is a prime example of Twining's common sense empiricism, an assumption that the notes would be freer from bias, and by extension that COI exists prior to its interpretation as raw data out there in the world. Now, of course, LP's barrister argued against this, saying, quote, "A filtering process needs to be applied to the evidence, and that is why an expert is needed." But even this, in my view, does not go far enough. The process of providing COI is not one of filtering out a truth that has been contaminated by selectivity or bias. It's fundamentally and inevitably interpretive by nature. Mike Redmayne has made a similar point, that not all biases are motivational, that is, the expert's bias that he wants one side to win. There are also cognitive biases, whereby the very perception of the evidence is affected by the professional paradigms within which one has been trained and acculturated. And this point's been made many times over by the chemist and philosopher Michael Polanyi, by Thomas Kuhn, The Structure of Scientific Revolutions, by my Edinburgh colleague David Bloor. Now, judges have tended to focus only on the first form of bias, maintaining, for example, that experts have political agendas. In other words, expert bias is seen as purely motivational, a failing from which judges appear to regard themselves as mercifully free. They seem wholly a cheap shot there, I'm sorry. They seem wholly unaware of the possibility of cognitive bias, which of course applies to them equally, as it does indeed to any professional group. UKBA's argument would have raised problems for me if the judges had accepted it. There's not, as far as I know, any decision in British courts on whether anthropological field notes are privileged documents. But if the judges had demanded my notes, I would have felt obliged to test the water by refusing on grounds of professional ethics. Happily, the judges concluded, quote, "In this jurisdiction, experts are not merely the providers of raw data, but they can be the interpreters of it as well." And to add just an extra frisson, I realised during these arguments, I hadn't known when I went into court, that the notebook in which I was transcribing them was the very one I'd used on my 2006 visit to Sri Lanka. So unknown to anyone in court, I actually had with me the very evidence that UKBA was unsuccessfully trying to elicit. Thank you.